1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်940ဒေါ်အုံးခင် applicant vs ဦးကျင်စိန် respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Revision before ဦးသက်ဖေ Judge ဒေါ်အုံးခင် applicant vs ဦးကျင်စိန် respondent Code of Civil Procedure Order 21 Rule 29 Stay of Execution Suit by Landlord against tenant for recovery of areas of rent Suit by tenant for recovery of money given as security Application for stay of execution by tenant Hell, there is no restriction whatsoever in Rule 29, Order 21, Civil Procedure Code that the stay can only be granted when the nature of the pending suit is identical or similar to that of the decree sought to be executed. The object of the rule is to prevent multiplicity of execution proceedings and to enable the decree holder and the judgment debtor to adjust their claims against each other when the judgment debtor has instituted a suit against the decree holder. Kanname vs. Muthu Kumara Swami Chetty AIR 1936 Madras 102 SM Nagori vs. Babu Rao AIR 1956 Matt Bharat 229 Tarini Prasad Rai vs. Narayan Kumari Devi ILR 17 Calcutta 391 refer to Achabi for the applicant, Tongwin for the respondent. Udape, Judge, the petitioner is the landlord of the respondent in respect of room number 1 in house number 57, Myanmar Street, Rangoon, at a monthly rental of Jet 150 in Civil Regular Suit numbered 429 of 1964 of the Rangoon City Civil Code, she sued her tenant and obtained a decree for Jet 1652 as areas of rent with costs. She then took out execution of decree in Civil Execution Case numbered 84 of 1965. In the meantime, the respondent instituted a suit being Civil Regular numbered 290 of 1965 of the same code against the previous landlord, Upo Tai, and the respondent for recovery of Jet 13,400 being the amount given as security to Upo Tai in respect of the room enter lease and apply for and obtain the stay of execution under Rule 29, Order 21, Civil Procedure Code, being dissatisfied with the order staying the execution, the petitioner has brought the present revision. It has been argued on behalf of the petitioner that the lower court erred in staying her execution case inasmuch as the respondent's suit was one for money pure and simple, which is essentially different in character from decree for rent obtained by her. Rule 29, Order 21, Civil Procedure Code reads, where a suit is pending in any court against the holder of a decree of such court on the part of the person against whom the decree was passed, the court may, on such terms as to security or otherwise, as it think fit, stay execution of the decree until the pending suit has been decided. A perusal of the rule will show that there is no restriction whatsoever therein, that the stay can only be granted when the nature of the pending suit is identical or similar to that of the decree sought to be executed. The object of the rule is to prevent multiplicity of execution proceedings and to enable the decree holder and the judgment debtor to adjust their claims against each other when the judgment debtor has instituted a suit against the decree holder. Thus, it has been held in Kaname vs. Muthu Kumaraswamy Chetty 1 that Order 21, Rule 29 embrace every kind of suit which is maintainable. There is no limitation in the rule. Once it is considered that a suit is maintainable, the procedure laid down in Rule 29 is at once attracted. The object of the rule is that should a plaintiff in a pending suit succeed therein, then there can be an adjustment of the decree or claim by the plaintiff against the decree obtained against him in the other suit in the same court without it being necessary for the successful plaintiff in the pending suit to take out execution proceedings. Execution in the other suit is stayed so that the rights of the parties can be adjusted in cases where it is likely that the decree holder in the other suit may take steps which might deprive the plaintiff in the pending suit of the fruits of any decree which he obtains. An order staying the execution in the other suit should be made. The rule is not an imperative one, and the court has a discretion either to grant the relief asked for, namely, stay of execution of the decree, or to refuse it. Then in S.M. Nagori vs. Baburao 2, it has been ruled that Order 21, Rule 29 clearly give wide powers and discretion to the court for passing a stay order. It has ample discretion in passing an order as to the terms on which the execution of the decree can be stayed until the pending suit has been decided. Besides, the areas of rent which has become due by a tenant come within the definition of debt as defined in Section 3, Transport of Property Act, and a decree for areas of rent must therefore be regarded as a decree for money. In this connection, it has been held in Tarini Prasad Rai vs. Narayan Kumari Devi 3 that a decree for rent obtained by a landlord against his tenant is a money decree. The learned advocate for the petitioner has submitted an ingenious argument that the stay is inequitable inasmuch as a landlord who is entitled to receive rents every month has been denied of his right, whereas the tenant is enjoying the tenements without any hindrance. Firstly, it must be pointed out that the order of the lower court has not the effect of prohibiting the petitioner from demanding the present and future rents. It applies only to the areas of rent which has ripened into a degree. Secondly, it must not be forgotten that the respondent had made a claim against the petitioner by instituting a suit, and the petitioner cannot therefore be allowed to harp on equities by pressing his rights alone while ignoring the claim of the respondent. Then an order under Rule 29, Order 21, Civil Procedure Code is purely a discretionary one, which will not, as a rule, be disturbed by the Code of Revision unless it can be shown that it is manifestly unjust or patently wrong. In the instant case, the order of the lower court cannot either be said to be manifestly unjust or patently wrong. In the result, the application for revision phase N is accordingly dismissed with costs, advocate fees, Jet 34.